Hey Braden, how's it going?
How's it going?
Good.
I'm doing good too.
That's good. We'll wait a little bit while people log in. I'll start giving you guys some credit. If anybody has some questions, uh, about anything really, but the operation of the course or let's see, Braden and Adam. Okay.
Yeah, I do have a question actually. Um, I wrote a brief a brief on Get Low v New York for this week. Should I send that to you or
Uh, yes, you could.
uh, do I like perform that on the Zoom or
We'll get low, and I'll ask you to do that. You can send it to me by
no?
email.
Okay.
It's posted on the discussions. Is everybody hearing the audio all right? I was hearing like maybe a little bit of double sound, but if you're not, that's good. Any other questions? While we wait to see if a few more people show up, I'm going to give you guys credit for being here. So, like I said last week, in general, for being in a meeting or posting to the discussion, say to give people 20 points, and then if they have some additional, like present a case, uh, I'll give them more. Jesse, what's your last name?
Likely.
Okay. There you are, right up towards the top. Okay. Anybody have, we'll always start classes with if anybody has something from the news that they want to present for extra credit. Adam, let's see, I'm getting you here. Adam, were you on last week?
Yes, sir, I was.
I thought you were. For some reason, I don't have you. I don't seem to show that I gave you credit. I thought I remembered you. Um, Hi, Emily. How's it going? Let me give you credit.
Hello. I just wanted
Are you the person who said you have a class conflict but can sometimes make it for half an hour?
yeah, I can make it for about like 30 minutes.
Yeah, okay, great. Let's see, Caleb, let me get you down here for some points. Did anybody say they have a story in the news they want to present about either First Amendment or the media? Okay, I got this caught up. All righty. Well, I tell you what, I'm going to, oh, Joe, you just showed up. Let me give you some credit too here before I head off to talk about the pretest. Oh, Joe, where are you? You were on last week too, weren't you, Joe? There you are. Okay. Yeah, I gave you credit last week. Okay. Okie doke. So I'm going to turn to the pretest and just go down it and Um, that's sort of a good way for us to get started because it has some of the more important things to learn in the course. As I said last week, and in my messages, the pretest doesn't count towards your grade. If you did badly, that's great because then that means there's lots of room for improvement. And so you take a post test, it's exactly the same test at the end of the course. And hopefully that shows that you learned a lot and therefore I taught you well. And so it's like giving myself a good grade. So if you got a bad score on the pretest, it's so much better for me. It's just a way to see, am I getting across the most important parts in the test in the course? And by the way, remember I mentioned this last week. There is an attachment to the first announcement called X First Study that has all the main points in the course. So that's always something good to refer back to. So the first question on the pretest, the First Amendment protects you from censorship by YouTube or Facebook. And the answer to that is false. The First Amendment begins, Congress shall make no law. Congress. First word of the First Amendment. And it doesn't mean just Congress anymore. It means any government, but YouTube and Facebook aren't government. So even though they may sometimes seem like the biggest threats to free expression, some people feel you're not protected. You're not protected by the First Amendment from YouTube or Facebook or any other social media company taking down your post.
Well, I remember hearing about that before. I just think it's a little bit dystopian because I understand that the companies themselves are protected by what they can choose to censor or not censor. But if the companies have collaborated to get to a point where the majority of people voice their opinions on these platforms, then affect speech they don't want to see because that's for the majority of people like say their opinions.
Right. Well, I mean, so you raise a good point. And uh, there was a Supreme Court case last year, actually, and it has a little bit of a local angle in that it was a case that was brought by the former Attorney General of the state of Missouri, Andrew Bailey, who, by the way, one piece of news over the week is that he was named, he
Is
resigned.
he lagging really bad for anyone else?
Say it again. What was the question?
Sorry, you're just lagging a lot. I couldn't hear what you were saying. I don't know if it was just my internet or yours.
No, I was experiencing it too as well.
Yeah, I'm having a little trouble myself. Let's see. Let me double check and make sure. Oh, you know what? I'm glad you guys brought this up. I'm gonna switch routers. Okay, so let's see if this causes less of a lag. I have two routers in my house and I was on the one that was sort of for the other end of the house.
Seems to be a little bit better.
Is
Yeah.
it better? Okay, okay. So Andrew Bailey was the Missouri Attorney General until last week when he resigned to become the Deputy Director of the FBI, along with Dan Bongino, who is a former FBI agent and social media influencer. And Andrew Bailey, the way he relates to this is he brought a case to the Supreme Court last year that they heard oral arguments in, and where he claimed that the Biden administration had coerced social media companies to take down mostly conservative posts, and that that amounted to a violation of the First Amendment. And if what the Supreme Court said was, maybe if there was actual proof of coercion on the part of the government to force social media companies to censor some sort of speech, then that would implicate the First Amendment because it would implicate the government. Government coercion would bring the First Amendment into play. But because in that case, there wasn't really any evidence of the government forcing the social media companies to take down posts. They would sometimes call up and say, you have a post about using Clorox to try to counter COVID. That's a that's a dangerous post. You should take it down. But they wouldn't say if you don't take it down, then we're going to punish you. So there was not the coercion, so there wasn't a violation of the First Amendment. Similarly, there were a lot of the social media companies had taken down the false information that was being put out by some conservatives that Donald Trump had won the 2020 election. And so that was taken down, but it was taken down by them because it was false. The social media company is actually, since that Supreme Court decision I was just talking about, the Wendell Bailey, in the case brought by Wendell Bailey, since that decision came down earlier this year. Most of the social media companies have decided that they're not going to monitor false speech, false and potentially dangerous speech on the internet as much as they did in the past. Elon Musk, in particular, on X, is doing very little monitoring of false speech, and is in fact engaging in some of it himself. Okay, back to the test. Whoops. Okay. I have to get the test back up when I switched routers. I lost the quiz here. Just take a second. And stop me at any point that you have a question. Don't hesitate to interject with a question like that. We will study later this is sort of a related issue. We'll study later in the course, like about halfway through, something called the Communications Decency Act. And it provides that social media companies basically cannot be sued for some false or libelous, defamatory posting that a third party puts on their website. I mean, it would just be impossible given for the social media companies to check all that stuff out. Yep. Hold on a sec. Hello, I'm on the front. Hi. Good. I'm on the front porch if you need me. Hi. Okay, question 2. The First Amendment is part of the Declaration of Independence. No. Declaration of Independence, all men are created equal. Life, liberty, and the pursuit of happiness are unalienable rights, but the First Amendment is not part of the Declaration of Independence. By the way, by the time this course is over, we will have entered the 250th anniversary of the Declaration of Independence, so you're going to hear a lot about it. The Declaration of Independence is, even though you don't want to confuse it with the Constitution. and you don't want to confuse it with the First Amendment, it is still a very important statement of Enlightenment values that are central to our country, equality, freedom, and consent of the governed. Before the United States fought the Revolutionary War, there really weren't other countries where the people were sovereign. And that notion of the people being sovereign is picked up in the preamble of the Constitution, "We the people." Let's see. Well, and one other thing about, so the First Amendment being part of being a constitutional amendment, is something you can go to a court and say, the government violated my First Amendment rights, whether they be, there are 5 freedoms in the First Amendment: freedom of speech, freedom to assemble, freedom to petition the government for redress of grievances, freedom of the press, and then a 2-sided religious freedom. There are actually 2 religion clauses. We'll get to those in the very end of the course. One is establishment of religion, which is the government can't say that, say, the Catholic Church or the Presbyterian Church is the government, is the state religion, and you have to worship it, and you have to pay taxes to it. I mean, one reason a lot of people came to the United States as immigrants was to get away from that kind of thing in England and in other European countries, and they have religious freedom. So the Establishment Clause says that it can't be an established religion. And that's been interpreted by the Supreme Court to say, for example, that the public schools can't start the school day with a required prayer. They can start the school day with a moment of silence where you can say a prayer to yourself or think about whatever you want to think about. But they can't force you to say a particular prayer. There can't be a prayer at a graduation ceremony in a public school, even though I think that sometimes is ignored in a lot of school districts. As of now, although this is being contested in some states, the schools can't nail the 10 Commandments to the wall in a public school classroom. Of course, none of this applies to private or religious schools because, back to that first word of the First Amendment, Congress. A private school and a religious school are not the government, so they can tell you what you should believe. And as a matter of fact, not only can they do that, but they can't be stopped from doing it because it's part of their religious freedom. That's the other part of the Religion Clause, free exercise of religion. If one of you were like the press secretary and always had a gold cross around your neck, and I told you that was really bothering me, and if you wore that to class again, I was going to give you an F for the course, I would be violating your free exercise of religion. There was a big Supreme Court case back from the middle of World War II, 1940s. One of the first free speech cases. It was West Virginia versus Barnett. West Virginia had a law that said all public school children had to salute the American flag, and Jehovah's Witnesses consider that to be a violation of their religion and their free speech as well, because they consider it to be idolatry to be saluting the American flag. And the Supreme Court said that the students didn't have to do it. And this was in the, this was like during this was during World War II when patriotism was really at a very high point, and West Virginia was actually kicking all the kids who didn't, the Jehovah's Witness kids who didn't salute out of school, out of class, and were actually pursuing criminal charges against the parents for not getting them in line. So that was a pretty big Supreme Court decision. Okay, back to anybody have any questions yet? Question 3, the First Amendment protects life, liberty, and the pursuit of happiness. False. The First Amendment, that's the Declaration of Independence. And you cannot, even though you can go to the Supreme Court and say, the government is violating my freedom. And you can win a court case against the government on that basis of the First Amendment. You cannot go to the Supreme Court and say, hey, they're violating my rights under the Declaration of Independence. The Declaration of Independence is a great document, but it is not enforceable in court. It's not, only the Constitution is and the laws and treaties are enforceable in the Supreme Court. Question 4, if a law contradicts the First Amendment, it is null and void. That is true. Any law, whether it be federal, state, city council, an action of of a school board, and any official action taken by any state actor that violates the First Amendment, abridges your freedom of speech, assembly, press, or religion, those laws are unconstitutional and cannot be enforced. That is actually that was not in the original. The Constitution doesn't make that entirely clear. It doesn't say the Supreme Court can declare a law unconstitutional. It does say that the Constitution and the laws of the United States are the supreme law of the land. So it sort of implies that. And there was a big case that you probably studied in high school or some other college course called Marbury versus Madison, which was in 1803, in which the Supreme Court said that if a law violates the Constitution, the law is null and void. And so the Supreme Court had the power of judicial review. And it's been that way ever since 1803. The first words, question 5. The first words of the First Amendment are, "We the people." False. "We the people" is the preamble of the Constitution. And its main significance is that it is a declaration right at the get-go of the Constitution that the people are sovereign, not a king. And this is not a monarchy. And that was in fact a very revolutionary idea that, like I said, grew out of the Enlightenment. The Enlightenment is that sort of period of history that came after the Middle Ages. And, first there was sort of the Reformation, where there was a more, where no longer was the Catholic Church the sole repository of truth about God. Luther tacked up his theses on the door, and and other churches began to form, and the idea that people could find their own religious beliefs and didn't have to depend upon the Pope for the answers to those beliefs. That's the Reformation. And the Reformation then led to the Enlightenment of the people having sovereignty and the importance of free speech um, and and empiricism and scientific empiricism that that through science and fact gathering one could try to approach the truth. Question 6. There was a consensus in Philadelphia in 1787 that the Constitution needed a Bill of Rights. No, false. The reason the Constitution did not have a Bill of Rights, and the reason was that there wasn't a consensus that they needed a Bill of Rights. Um, the some of the leading advocates of the Constitution, the ones they were called Federalists, and they argued that the Constitution should be ratified. And they thought that because they had a separation of powers and limited government, that there wouldn't be a need to have a separate list of freedoms that were protected uh, for the people from government interference. But to get the Constitution, there was a big anti-federalist contingent that didn't want to ratify the Constitution. And to get enough votes to get it ratified in enough states for it to take effect, some of the Federalists had to promise that if they were elected, that if it were ratified, that they would add right away a Bill of Rights to the Constitution. So James Madison, who was he's sometimes referred to as the father of the Constitution or the father of the Bill of Rights. He was the 4th president of the United States. James Madison took up that job as soon as he was elected to the first Congress and wrote the Bill of Rights. Actually, what he wrote had 12. Proposed uh, articles in the Bill of Rights. The first 2 were not ratified. So initially he had what we call the First Amendment. He had his 3rd Amendment. So it's not like it's first because it's most important. It probably, amongst the parts of the Bill of Rights, it probably is the most powerful. It probably is the most important as the history of our country has developed. And so the other parts of the Bill of Rights, the Second Amendment is right to bear arms, get to have a gun in you have a constitutional right to have a gun in your house for safety purposes and to carry a gun. The Third Amendment, it was something the founding fathers cared a lot about, but it's not relevant very much anymore. That you can't be forced to quarter troops in your house. The British used to force colonists to put up their redcoat soldiers before and during the Revolutionary War, and there was also people were very angry about that. Fourth Amendment is you are secure and safe in your house, in your house and your papers and effects. So it's like it's a protection against the government conducting an unreasonable search and seizure. So the government has to prove before it can search your house or your car or your person, they have to prove that they have a good reason. That oftentimes will mean that they need to have probable cause and a search warrant. Well, it doesn't always mean that. If there are exigent circumstances, they're chasing you from a crime, they don't have to go get a search warrant. Fifth and Sixth Amendments are all sorts of protections in from for the criminal and justice system. So right to remain silent. Government can't force you to confess. Right to a trial by jury, right to have a lawyer. If you could be incarcerated if you're convicted of a crime. A jury of your peers, right to remain silent. I think I said that. Eighth Amendment is the Seventh Amendment is no excessive civil fines. The Eighth Amendment, well, no, that's not true. Excessive civil fines is in the Eighth Amendment, and also no cruel and unusual punishment. It's under that part of the Constitution that the Supreme Court has said that young people who commit murder can't be executed, commit any crime, can't be executed. Ninth Amendment says if we didn't mention it in the first eight, those rights still remain with the people and not with the government. And the 10th Amendment protects states' rights against the federal government. So that's the Bill of Rights, and I believe that there are definitely more. Well, I was about to say there are more First Amendment cases than any other, given the fact that the reasonableness of searches and seizures is oftentimes an issue in a criminal trial. I suppose there's probably more litigation on the Fourth Amendment than the First Amendment. No law had been declared. If you could turn the clock back 100 years to that period of time, we're gonna talk about in a couple of minutes of the First World War. The Supreme Court had not declared any law unconstitutional for violating the First Amendment. So the whole sort of history of First Amendment protection has been over the last century. And for the first half of that period of that time, up till say, the 1980s, maybe, the First Amendment mostly sort of protected people challenging the government, sort of rabble rousers, union leaders, socialists, in some cases communists, people who are protesting. In the last 50 years, it's oftentimes ended up protecting the rights of sort of more well-heeled people, corporations to make unlimited expenditures to elect the candidate of the corporation's choice. Think back to the very past election. Elon Musk spent $250 million to help elect Donald Trump. Also another example of First Amendment rights, our First Amendment values being interpreted to favor the more well-heeled. It was a case called Hobby Lobby, where the Supreme Court said that a family corporation like Hobby Lobby didn't have to abide by laws that required contraceptives to be provided to female employees of their company. So the people winning more recently in First Amendment cases are in general more well off than in the first half in the first half century of the First Amendment having power. Let's see. Um, question 7, the right to bear arms is part of the First Amendment. False. It's the Second Amendment. The First Amendment, 8, the First Amendment protects the right of free speech around the world. False. Only in the United States. You go to Russia and you say Vladimir Putin is a war criminal who's holding Ukrainian children against international law, and and the police arrest you. You can't say the First Amendment protects me here, because I'm an American citizen and I'm protected by the First Amendment. They'll throw you in the gulag anyway. It doesn't protect you outside the United States. I had a student who did a little for a master's project, and he discovered that because of a set of Supreme Court cases decided around the early 1900s called the Insular cases, that the First Amendment also doesn't protect you in Puerto Rico or territories like Puerto Rico. So if you go to Puerto Rico, you've got to be a little more careful. But the First Amendment does protect one sort of, this was not on a question on the test, but the First Amendment does protect persons who are not citizens. It's not just to protect an American citizen. It may not protect the rights of immigrants as robustly as citizens. So some of these cases where pro-Palestinian protesters who are here on a green card are making speeches, it may not entirely. It's a matter of legal debate whether or not that immigrant making those claims has the same First Amendment rights as an American citizen. So that's something that's being hashed out in court. But in general, all persons have First Amendment rights, not just citizens. Let's see here. The Sixth Amendment requires the media to ensure that a defendant get a fair trial. False. It requires that the defendant get a fair trial, but it's the judge's job. So, like if a newspaper or a news organization of some sort writes a story about a trial, the judge might get mad at them, but in general, but it's not necessarily the news organization's job to ensure that there's a fair trial. I'll give you an example. We'll talk about this a little bit later in the course. You all may remember Barry Bonds was the home run king, beat Babe Ruth's record, most home runs in a season, most home runs, I guess, in a career. And it turned out the San Francisco Chronicle got a story that he had been using performance enhancing drugs during the last part of his baseball career. And they published that story. And the way they got that information was that a criminal grand jury in San Francisco had a case against the chemical lab that produced the performance enhancing drug. It was called Balco. And the reporters for the Chronicle were given grand jury transcripts of that investigation that showed that Barry Bonds had been using these performance enhancing substances, as well as a bunch of other ball players. Mark McGwire of the St. Louis Cardinals being one example. When Mark McGwire was called before the congressional hearing about it, he said he took the Fifth Amendment. that he wasn't required. His answer might tend to incriminate him violating a law. Um, so not just Barry Bonds, but a bunch of ball players were doing that. And so the grand jury transcripts were leaked to the reporters, which was the source of the story. And I mean, it was a heck of a story. It got all sorts of national awards. It resulted in congressional hearings about baseball violating, um, violating its own rules and violating laws in the way that they were regulating steroids and other performance enhancing drugs. And those were the hearings where people like Mark McGwire were called to testify. And it resulted in baseball reforming how they enforced the steroid rules. But the Barry Bonds lawyers and Balco's lawyers in court said, "Hey, the grand jury transcripts. This is making these stories about these grand jury transcripts are making the trial unfair." And the judge, of course, has a job of trying to make sure that Barry Bonds gets a fair trial. So and grand jury transcripts are in general secret. There are exceptions. The government can release grand jury transcripts under some circumstances. This issue has come up in connection with that with the Epstein case. You all may remember when there was a grand jury investigation of Darren Wilson, the Ferguson cop who shot and killed Michael Brown. And the prosecutor in that case released excerpts of the grand jury transcripts. So sometimes grand jury transcripts come out, but they're in general secret. The reason they're secret is so a person can get a fair trial, and so that there can be a criminal investigation. And if a person is cleared in the investigation and never criminal charges laid, then their reputation won't have been wrecked. Almost always a grand jury will indict the person who a prosecutor wants indicted. Although there are actually some examples very recently in Washington, D.C., where some of the people whom the Trump administration has tried to indict for interfering with ICE officials making arrests, the grand jury in Washington has refused to indict them. There was one guy who threw a sandwich. A former government employee threw a sandwich at I guess it was an ICE agent, and the government wanted to indict him for felony aggravated assault, and the grand jury wouldn't do that. So, but at any rate, so back to Balco and Barry Bonds. So the judge tried to make the reporters tell him who their source had been, and they would not disclose their sources. At any rate, it's not the reporter's job to make the trial fair. It's the judge's job. Question 10. You know what? Before I go on, I'm going to see if I've missed anybody new who joined us. Let's see. Tiffany Lazane, am I saying that right?
Yeah. I was just gonna say, uh, I know I just joined and I emailed you because I was having a problem with like the Zoom link, finding it and just like getting to it, I guess. But I was just making sure I was gonna get those points today since I have class at 11.
Yes, yes, you will, and I'll give them to you right now so that I don't forget. Just a sec. Okay, where is my grade book? I got too many things minimized up here. Okay. But you were able to solve the Zoom problem, I take it, since you're on the
Yeah, I
you're on
found
the
it.
call. Okay, good. Um,
Oh, hold on. I have a question
shoot.
going off that. So it's just that one link in the first email, because that's how I found it.
Yeah, you know what? I'll tell you what I'll do. I will post so it's the same link for every course,
Okay.
every class. So what I will do is I'll put that on. I'll put an announcement on the announcement page with the link.
Alrighty. That'll
'Cause
work.
I don't want you to have to go find it every time. Any other questions so far through the first part of the pre-assessment? Okay, back to it then. Let's see. The First Amendment protects a constitutional right to know. You hear that a lot, but it doesn't actually do that. I mean, so the answer is the answer is false. The one argument one could make that it protects something of the right to know is that, I mean, if there were a scholar or an author who was writing about a particular subject that the government thought was controversial, and they tried to ban research on that subject, that would violate a person's First Amendment right. But in general, I mean, there's nothing explicitly that protects the right to know. The First Amendment begins, Congress should make no law. No law means no law, no exceptions. False. I mean, this is an example of my the way I sometimes write these true false questions. The First Amendment does say Congress shall make no law, but no law does not. So that first sentence of that question is true, but the whole question is false because no law doesn't mean no law. There have been a few justices who said no law should mean no law, but there are a lot of exceptions to there's lots of kinds of speech that are not protected by the First Amendment. For example, um, conspiring to commit a crime, um, true threats. I'm going to kill you. Under circumstances that make it clear that maybe you got a gun in your hand or something, or a knife. It can't be just some sort of rhetorical, I'm going to kill you for that. Threats against the president's life. Those are not protected. Obscenity is not protected speech. Um, um, Defamation, something that wrecks somebody's reputation, and where the person wrecking the reputation basically knows that they're making a false claim. There's lots of in the polarized world we live in, there's lots of defamation cases. I mean, Fox News had to pay $750 million for their false coverage relating to the 2020 election, claiming election fraud. And Rudy Giuliani, the president's lawyer during that election, had to pay a bunch of money because of claiming that two Atlanta poll workers were stuffing ballot boxes when that wasn't true. Um, um, more recently, ABC agreed to pay Donald Trump um, uh, for in a defamation case where George Stephanopoulos, the ABC commentator, had said that a jury had found that Trump had raped Jean Carroll in a 1990s incident at the New York department store. And Trump sued. Trump claimed that he didn't even know who this person was. And she wasn't his kind. But the jury found that he had sexually assaulted her. But they also found that he had not raped her as that term is used in New York criminal law. So that was the basis of Trump's defamation lawsuit. The jury had found that he had digitally, I'm sorry to get into these kind of details, penetrated her, and that is the normal definition of rape, but not the definition of rape in New York State. So that was George Stephanopoulos' defense, because the judge in the case had said it amounted to rape. Normally that'd be enough to win, but ABC, owned by Disney, capitulated and agreed to pay $10 million for Donald Trump's future library. Okay, so all that to the point that not all speech is protected. So no law doesn't mean no law. I have a whole in that X-First study document that's appended to the first announcement, the welcoming announcement. I've got a list of all the instances where speech doesn't protect you, where the First Amendment doesn't protect you under the First Amendment. 12. The First Amendment was part of the Constitution when the Constitution was ratified. No, it was added in order to persuade people to vote for the Constitution. 13. The first time the Supreme Court threw out a law for violating the First Amendment was in the 1800s. False. The Supreme Court didn't throw out a law for violating the First Amendment until the 1930s. So like, I don't know, about 80 years ago. Question 14. When people speak at the city council, their speech is protected by the First Amendment. True. But so I'm speaking to you from my home in Kirkwood, Missouri. Kirkwood in 2000 and I think it was 7, might have been 8, had a city hall massacre. And the person who did the shooting was a young man who had grown up in Kirkwood, like I did, and but he was a black citizen who felt as though the city council had discriminated against him. He felt as though he had been promised a demolition contract to clear land for some construction. And he started going to city council meetings with bales of hay, dressed in overalls, saying what a plantation Kirkwood was, and interrupting the city council meetings. So you don't have, even though you have a First Amendment right to speak at a city council meeting during some sort of like citizen feedback time, you do not have a right to disrupt the city hall meeting. No, just like you have a right to march, to assemble under the First Amendment, and to march for your political cause, whether it be conservative or liberal or someplace in between. But you can't violate generally applicable laws. You can't block the street. You can't throw bottles at the police. If the police declare the assembly to be an unlawful assembly because some people are throwing rocks and bottles or breaking windows, then you don't, First Amendment isn't going to protect you. That gives you another idea of some of the limitations. Question 15, a citizen can shout at the mayor and disrupt the city council meeting and be protected by the First Amendment. So, false. As the Cookie Thornton assault in Kirkwood illustrates. By the way, I didn't finish the Cookie Thornton story. He marched into the city hall, killed 2 cops walking in, killed 2 city council members, and injured the mayor severely enough that he died several months later. So obviously none of that's protected. And it was a tragic incident. Question 16, if the city council starts a meeting with a prayer from a Christian chaplain from town, it violates your religious freedom. False. The Supreme Court has ruled that a city council can start a town meeting with a Christian chaplain or a Jewish rabbi or any other person that they invite. Lots of public meetings begin with prayers. Supreme Court has ruled that that Congress and state legislatures can use taxpayer money to pay for chaplains to say prayers to start the legislative day, and that does not violate the establishment of religion in the First Amendment. And in fact, the Congress begins every day, I think every day, with a prayer from a chaplain. And most state legislatures do as well. Question 17. Your public high school can't allow a chaplain from a local church to give a prayer at your graduation ceremony. That's true. Actually, I interviewed the little girl. The case was called Weissman versus Rhode Island. It was a little girl in Providence, Rhode Island. I went to interview her and her family when this case was before the Supreme Court in the around 1990. And what she said was that she didn't want to be forced to pray to somebody else's God. And Supreme Court agreed with her. The Supreme Court is taking up some issues that could end up altering the way in which the Establishment Clause is interpreted in ways that could permit this kind of thing in the future. But we'll see. That as of now, that is not permitted. What most public school districts do is that they'll have like a separate have the churches in town have a separate observance of kids' graduation that's not at the school or on school grounds and separate from graduation. City council can spend money to set up a Christmas display with nativity scenes that has the baby Jesus, as long as there are also secular symbols like a Christmas tree and Rudolph the Red-Nosed Reindeer. True. The case is something called, I think, Pawtucket. And so a city hall cannot set up a creche scene with the baby Jesus as like its only observance of the winter holidays. Pittsburgh tried to do that in Allegheny County, and the Supreme Court said you can't do that because it makes everybody who's not a Christian feel as though they're outsiders in their own town. But more ecumenical displays that include religious symbols, might include a Christian creche scene and a menorah or a Star of Liberty. Those are protected and do not violate the Establishment Clause, as the Supreme Court interprets it. If question 19, if your parents tell you you shouldn't take the Lord's name in vain, they are violating your First Amendment right to free speech. False. Your parents are not Congress. If your family says you have to go to church, they're violating your First Amendment freedom. Same deal. Your family can tell you anything they want to tell you. And they're not violating your First Amendment rights. The parish school can require students to take a religion class. True. That's part of the religious freedom that that religious and private schools have. It's only public schools that have the limitations of no state-approved prayer to start the school day. Question 22. News organizations can publish top secret documents without being prosecuted. That is that is true. So we'll study a number of different cases. The reason I'm hesitating is that they're like one of the cases we will study is the Pentagon Papers. Daniel Ellsberg leaked a 45-volume history of the Vietnam War that showed that every president from Harry Truman through Dwight Eisenhower and John F. Kennedy and Lyndon Johnson and Richard Nixon had lied to the American people about the Vietnam War in one way or another, mostly to say we're about to win this thing, when generals were telling when they knew that was not true. But also in many other ways, such as the legal basis for the escalation of the Vietnam War in the 1960s was something called the Gulf of Tonkin Resolution. And it was based upon Lyndon Johnson's claim that North Vietnamese gunboats had fired on U.S. naval ships in the Gulf of Tonkin. Congress, with only one dissenter, Wayne Morris of Oregon, voted to authorize all appropriate military action in response. That led to, an enormous escalation of the war in Vietnam, with hundreds of thousands of American troops being sent, more than 50,000 killed, American soldiers, a million Vietnamese, South Vietnamese, and a couple of million North Vietnamese and Viet Cong. But the Gulf of Tonkin turned out to be a lie. One of those things in the fog of war, the details were never clear, but it was a very it didn't happen the way President Johnson had said that it did when he was trying to get Congress's approval. So the New York Times was given this 40-volume classified document and began printing. They began printing on June 12th of 1971. The reason I know that is that's the day I graduated from college. so I can sort of remember it. And the next day, or within the next day or two, the Nixon administration went to court to try to get an injunction ordering them to stop. And the Supreme Court eventually issued a decision saying that that violated the First Amendment. The government can't engage in that kind of prior censorship. And so the New York Times and other news organizations by that time, the Washington Post, the Boston Globe, the St. Louis Post-Dispatch that I work for, all had begun to publish those stories. And they were not prosecuted. Daniel Ellsberg was prosecuted. So the leaker of national security secrets is usually violating like an agreement they made to be in the government, and they're violating something called the espionage law, which we will talk about later in today's course, because the espionage law was passed in that period of time around World War One that makes it illegal to provide information that helps the enemy. And so most people who leak information are prosecuted. The leaker themselves under the Espionage Act, although only one self-described journalist has ever been successfully prosecuted under the Espionage Act. Only one has ever been charged under the Espionage Act. That's Julian Assange for the WikiLeaks leaks. And he recently pled guilty to sort of get out of, to get back his freedom. He had been hiding in the Ecuadorian embassy in Britain. And the reason I say self-described journalist is because there's pretty much of a debate amongst journalists and lawyers, First Amendment lawyers, about, is Julian Assange really a journalist? He says he's a publisher. But the thing is that Julian Assange's background is he's basically a hacker. I mean, he helped Bradley / Chelsea Manning, who got most of the WikiLeaks documents, who hacked most of the WikiLeaks documents. He helped Manning do it. And although he denies it, the investigation seemed to say that he provided on behalf of Russian intelligence the hacked DNC and Hillary Clinton emails that were leaked before the 2016 election. So he's very much a sort of a hacker and political mischief maker. I mean, in the 2016 election, he was basically doing the bidding of Vladimir Putin. But the overall thing to remember is that news organizations print national security secrets and are not prosecuted for doing so. Usually, a news organization like the New York Times or the Washington Post, which are the ones that do most of this kind of publication, usually they will let the government know that they're about to publish, and to make sure that they're not going to like endanger anyone, endanger an intelligence agent or somebody from another country who's cooperating with the United States. Okay. We're almost done with this pre-assessment. 24. The First Amendment protects all religions equally, Islam as well as Christianity, and protects burning the Bible or the Quran. True. Or the Constitution or the flag. The First Amendment protects hate speech and a public student's right to say a prayer before an algebra test. True. The KKK burning crosses in an Ohio farm field, that's protected. And you could say a prayer. I mean, if when you sit down to take the final in this case, in this class, if you want to say a prayer, you got First Amendment free exercise of religion, uh, protects your right to do that. Maybe it'll even help. Let's see. The question 26, the First Amendment protects the right to petition the government for redress of grievances, and that protects rich lobbyists who try to get laws passed to help their economic interests. Yes. So the lobbyists and Gucci loafers who get Congress to do their bidding, they are protected by the First Amendment. Just like Elon Musk was in spending $250 million in the last election. And just as George Soros is in his very large contributions to Democratic candidates and political committees. Okay, 27. The First Amendment protects the internet and newspapers more than it protects TV. True. We have something called the FCC, Federal Communications Commission, and it regulates the broadcast airwaves. FCC can't tell a newspaper, can't regulate what a newspaper prints. And it does have some power over the internet, but it doesn't ever regulate what the content, at least up till now, hasn't regulated the content of online publications. But it can, but the FCC does regulate broadcast. So, for example, one of the classes we'll talk about George Carlin's 7 Dirty Words and monologue, which are basically all of the words that you can't say on broadcast TV, and that the FCC ruled violated the indecency laws. By the way, is my voice, are you hearing me? Because there is a vacuum that's around, not too far away. Is that interfering with your hearing me?
No, I'm only hearing you right now, so
Okay.
you sound good.
Okay, good. Let's see. University speech codes that ban hate speech and may violate the First Amendment if they protect some groups and not others. True. The First Amendment is very much a hold on a second, I'm going to close the door here. Okay, I'm back. So the First Amendment doesn't favor any particular ideology. It doesn't even, in general, protect truth over falsity. It protects false political speech. Although, that's only to a certain limit, as in defamation cases, falsity can can end up in your speech not being protected. If you're engaged in the reckless disregard for the truth. We'll talk about that a lot in connection with the New York Times versus Sullivan defamation case, which is the first case we'll read after the first test. So, like if a university has a speech code that, has what people might say were like woke limitations on speech, that could violate the First Amendment. There was a law professor at the Northern Ohio University. His name's Scott Gerber, who wrote a letter to the Cincinnati Enquirer newspaper saying that the university's um, uh, pursuit of diversity in hiring had resulted in some people not being considered for positions on various faculties, and he was fired for writing that um, that column to the local newspaper, and that violated his First Amendment rights. A corporation could spend up to $10 billion to help elect the candidate of its choice. True. Although I think, that's sort of an exaggerated amount because Elon Musk, I think, set the record with his 250 million in the last election. So I don't think we've gotten to, and of course, Elon Musk is not himself a corporation, but he could certainly use he could have used all SpaceX and X money to fund those payments on President Trump's behalf.
I have a question on that.
Yeah, go ahead.
Isn't I thought there was like there was a cap to how much you could donate to a
Yeah.
political party.
Well, that's a good question because yes, that was true. And in like our second to last class, we'll probably in almost around Thanksgiving or something, we'll talk about the campaign finance laws. And the Supreme Court, so Congress passed a law after Watergate that limited campaign contributions and expenditures. It was, and the reason I say after Watergate is that it was campaign money that was used by the Nixon White House to burglarize the Democratic National Committee headquarters and also conduct a lot of other sort of political dirty tricks. But there's if you ever, and this is a movie you guys could watch if you wanted a good old movie, if you don't mind if the movie maybe moves a little bit slowly. All the President's Men, about Woodward and Bernstein of Washington Post fame, digging out the Watergate story, and there's an aha moment. Well, Deep Throat, who is the nickname they use um, for the FBI source who's providing them tips. Deep Throat tells them, follow the money. I think it's actually apocryphal. I don't think, I'm not sure he actually said that, but that's the way they recalled it and put it in their book. And so there's something that did actually happen. I mean, Deep Throat was a real source of theirs. His name was Mark Felt. He was the acting director of the FBI, and he was mad at Nixon because Nixon hadn't appointed him to take J. Edgar Hoover's place when J. Edgar Hoover dropped dead. But so there's this aha moment in All the President's Men where they're trying to figure out where the some of the money that had gone to the burglars had come from. And they call up, they have a name from a check and they call up the person and it turns out to be a campaign contributor to the committee to reelect the president, which some of the critics in those days called creep. And so as it turned out, the Watergate burglary was funded by campaign contributions to Nixon. And so Congress passed the laws to regulate contributions and expenditures. The Supreme Court, in a case called Buckley versus Vallejo, we'll read the case around Thanksgiving, said Congress can limit contributions to a candidate, but that Congress could not limit how much a candidate could spend to get elected. And so basically that ended up meaning rich people could spend all their money to get elected, and some millionaires spent $25 million to try to get elected. Sometimes not succeeding in the process. So that was the initial Supreme Court take, and then later, after more stringent limitations on campaign money were passed by Congress, the Supreme Court had a decision called Citizens United, in which it said that a corporation or a labor union could spend an unlimited amount of their treasury money. So Exxon could spend its entire treasury paying for, say, campaign ads or for get out the vote efforts to help a particular candidate get elected. What they cannot do is they cannot give corporate money to a particular candidate. They can buy the campaign ads. They can buy the ads urging the voter to elect the candidate, but they can't give that money to the candidate's campaign committee for a candidate expenditure. So it gets a little bit complicated, but mostly the very big campaign, TV campaigns for particular candidates are funded out of these unlimited contributions from rich people who are sometimes using corporate political money to fund their contributions. So you've got sort of like an Elon Musk versus a George Soros. The people who have the most money don't always win. I think in 2016, Hillary Clinton had more of that big unlimited money than did Donald Trump. And of course, Donald Trump won. I think that in 2012, I think that maybe Romney had more of that money and lost to Obama. Yes, there are limitations on campaign contributions to candidate committees, but there are no limitations because of the First Amendment. Says that political expenditures are the equivalent of speech. There are no limitations on how much can be spent by corporations or labor unions or any other interest groups to get a particular candidate elected. Okay. Last question. A person who finds a funny picture on a news website can post the picture to YouTube as long as the person who drew the picture gives or who took the picture, as long as the photographer is given credit. And the answer to that is false. So this gets into copyright. In early November, we'll talk about intellectual property of various kinds, including copyright. Intellectual property is trademarks, patents, copyrights. And so just giving credit for something you find on the internet that you want to use in some publication of your own to the internet isn't good enough. You got to get approval or pay the fee to use copyrighted work. So that's another limitation on speech. Okay, that is the pre-assessment. You guys got any questions? Or have I just confused you? No, don't answer that. Okay, so let's start talking about the period around World War I when the First Amendment comes alive. And this is a time when the country is very much in turmoil. People are scared about a lot of things. I'm looking for a little summary. You'll find, sort of the order we're going to take this in terms of cases. You'll find in an attachment. It's an attachment to the announcement on first test review sheet. There's an attachment at the end of that says Schenck through RAV. And these are the initial Supreme Court decisions where the court began to give more and more, give the First Amendment, recognize more and more power and clout for the First Amendment. And so amongst the things that people were frightened about were World War One. Soldiers were coming back from World War One shell-shocked. Which was a term that people used for what we now call PTSD. Also during this time, the Ku Klux Klan was at a high level. There were a lot of lynchings. East St. Louis race riot resulted in more than 100 blacks in East St. Louis being lynched or thrown into the Mississippi River from the bridge. Tulsa followed shortly thereafter. There was lots of labor strife. There were the immigrants from Southern Europe, Italians, were looked down upon by a lot of Americans and were thought to be, inferior. There were anarchists and socialists who made people afraid. The Bolsheviks took over Russia in 1917 and created the Soviet Union, pulled Russia out of World War One, and created the Soviet Union. So that was another thing that Americans were even then afraid of, although they became more afraid of it as time went on. There were the Attorney General of the United States, his home in Chevy Chase was bombed, and a young J. Edgar Hoover, who later went on to run the FBI, was put in charge of what were called the Palmer raids, named after that Attorney General whose house was blown up, Mitchell Palmer. They rounded up thousands of people with no criminal charges against them. With no case against them. And so, the other turmoil that was underway in this period of time, although, not necessarily frightening, was that this was when women were winning the right to vote. 19th Amendment was ratified in 1919 and finally approved in in uh, eh, um, in 1920. So there was a lot going on in this period of time. And so some of like World War One and the Bolshevik Revolution in Russia are partly responsible for some of these early cases, First Amendment cases that we talk about. Did anyone do Schenck? Adam, was that you raising your hand, or does anybody want to present? Well, let me put it this way. So we're going to start out with this set of World War One cases: Schenck, Debs, and Abrams. Does anyone want to present any one of those? I mean, I can do all the work, but that makes me sad. So if anybody wants to,
Do you just want the facts?
yeah, I just want the facts and what the court decided, and you can tell me what you think about it if you want. But yeah, just tell us what you know about it.
Okay, so defendants were convicted of a conspiracy to violate the 1970 Espionage Act. Schenck printed and circulated thousands of copies of a document that criticized the draft only 2 months after the United States entered World War I. The government alleged defendant worked to obstruct recruitment and influence members of the armed forces to refuse orders. Schenck appealed his conviction on the grounds that the Espionage Act violated his First Amendment right to freedom of speech. And the Supreme Court ruled that there are circumstances where Congress may abridge speech, even if such speech would normally be protected.
And what were those kinds of circumstances that they talked about?
Because we were in wartime, it was so detrimental to spread that kind of narrative that it presented a clear and present danger. So
Yeah, that term that you just used, clear and present danger, that was an important uh, term that was in the decision. Who do you remember who wrote it?
I believe it was Justice Holmes.
Right, Oliver Wendell Holmes. And over the course of these cases we're talking about, Schenck, Debs, and Abrams, you'll notice that his approach to the First Amendment changes pretty radically. So in some of in Schenck, he says at one point, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. That's sort of that's a famous expression. I mean, it's probably the single most quoted Supreme Court line in history. Although, and I hasten to add, although this doesn't really relate to this doesn't really relate to the First Amendment, that Justice Holmes is also known for a famous line in another decision he wrote about a decade later called Buck versus Bell. Buck versus Bell was on whether states could forcibly sterilize women if they thought if they thought the women were going to produce babies that were mentally challenged in some way. And the Supreme Court said yes, that the state sterilization laws, in this case, I believe it was in Buck versus Bell, it was Virginia, I believe, the forced sterilization was permitted. And Justice Holmes famously said, 3 generations of imbeciles is enough. So, so but Justice Holmes was a very, very smart justice and wrote some of the most, wrote some very stirring kinds of Supreme Court decisions. But so man, free speech doesn't protect a person falsely shouting fire in a crowded theater and causing a panic. And then he goes on to say the question in every case is whether the words used are in such circumstances and are of such nature as to create a clear and present danger that they will bring about substantive evils that Congress has a right to prevent. When a nation is at war, many things may be said that may be said in a time of peace are hindrances to that effort, and those utterances will not be endured. So he basically says that Schenk's document about military service being like slavery and violating the 13th Amendment for that reason, that was not permissible because it might disrupt, cause protests that would disrupt military recruitment and the draft, which was then being used to raise the U.S. Army. Did anyone do Debs? Eugene Debs he ran for president. He got tens of millions of votes. He was a socialist candidate for president. He had run in 1916. He may ran, I'm not sure if he ran in 1920 when he would have been in prison for espionage. But he gave a speech at an Ohio fairground in which in which he also likened military service and the draft to involuntary servitude and slavery. And he was given a 10-year sentence under the Espionage Act for obstructing military recruiting with a speech about socialism, and where he said he had admiration for socialists in jail for obstructing military recruitment. The Supreme Court said that kind of speech had the natural tendency and reasonably probable effect of obstructing recruiting services. Are you guys hearing a lot more, or can you still hear me?
You're good. I don't hear a lawnmower or anything.
Great. So then comes Abrams. Abrams involves espionage convictions for some actually sort of pro-Bolshevik protesters who threw leaflets off the roof of a factory in New York, opposing the capitalist invasion of Russia that opposed the Russian Revolution. It called for workers to rise up and oppose what the U.S. military was doing in Russia. During this period of time when the Bolshevik Revolution was going on, I mean, I don't really know all the details of this, but there was some sort of U.S. expeditionary force that was sent to try to interfere with the overthrow of the government. And that's what they were trying to protest. And you can see a change in over just this 1 year in the Supreme Court, and particularly in Justice Holmes, because Justice Holmes dissents, joined by another famous justice, Louis Brandeis, who had just come onto the court. Brandeis was the first Jew Jewish justice on the court, and his um his nomination for the court was held up for quite a while because of anti-Semitism. But Holmes and Brandeis dissent, and he said that there's no doubt that the U.S. can punish speech that produces or is intended to produce a clear and imminent danger that will bring forthwith substantive evils that the U.S. can constitutionally prevent. But he goes on to say, it is only the present danger of immediate evil or the intent to bring it about that warrants Congress setting limits on the expression of opinion. Congress certainly can't forbid all effort to change the mind of the country. Nobody can suppose that a surreptitious publishing of a silly leaflet by an unknown man without more would present any immediate danger. In other words, he's saying these people throwing these leaflets off the top of a manufacturing plant. I mean, who would think that that's going to have any effect on anybody, or much less the war? And then this is sort of famous language. When men have realized that time has upset many fighting faiths, they will come to believe even more than they believe the very foundations of their own conduct, that the ultimate good desired is better reached by the free trade of ideas. The best truth is the power of thought to get accepted in the competition of the market. So this is a sort of free market conception of free speech. And what had happened between Schenck earlier in 1910, and Abrams was that the summer had transpired, and the New Republic had written a very critical piece about Justice Holmes, and more importantly, his colleagues at Harvard Law School, his former colleagues at Harvard Law School, took him to task for having used this term in Schenck of clear and present danger, but then not really applied it seriously. And so what they convinced him to do is really lay out a much tougher explanation of what clear and present danger was. And that's this line about the present danger of immediate evil or an intent to bring it about. So it can't just be a bunch of rhetoric as it had been in the previous cases. But again, they're still even under these circumstances, they're still losing. It's a 7-2 decision. Did somebody say they did get low, or did that person leave though? Okay,
Yeah, I did get low.
tell us about Gitlow.
Okay. So, Gitlow, he was the defendant. He was kind of part of this kind of left wing of the Socialist Party, and the left side had adopted like a left wing manifesto, and it kind of condemned like socialists who were moderate or maybe not radical enough, and Gitlow organized like the printing and distribution of 16,000 copies of that manifesto, and um, he was convicted under the New York criminal anarchy statutes, because in the manifesto it kind of called for radical overthrowing of the government, and even through violence, I believe. The ruling was that the First Amendment, or sorry, I guess I should have started with the issue. The issue of the case was, does the First Amendment protect speech and press that call for and instruct government takeover? I put takeover, but you could also say overthrow. And the ruling was that it doesn't protect Gitlow from the New York statutes that were in place. The vote was 7-2 in favor of New York. and then for the like opinion part, I'm kind of paraphrasing Justice Sanford here. Using speech to advocate for forcefully overthrowing the government can be penalized when the threats are real and substantial. The statutes of New York can only be considered unconstitutional if they are arbitrary, unreasonable. Penalizing citizens for threatening to overthrow the government is not unreasonable. And he argued that Schenck versus United States established that question is whether the words created a clear and present danger, and he obviously thinks they do because the pamphlet does call for violent takeover. And the dissent was Holmes and Brandis again, and they dissented. They said the only difference between the expression of opinion and an incitement in the narrow sense is the speaker's enthusiasm for the result. If the publication of this document had been laid as an attempt to induce an uprising against the government at once and not as some indefinite term in the future, it would have presented a different question. So because the pamphlet doesn't like call for immediate government takeover, like there's no like specific date for when to do it and when everybody's going to organize and meet up and commit the act, that it isn't immediate danger. It has no substantial evil, and that's how they dissented on that. So
Right, so it's not really a clear and present danger because there's there's no likelihood that anybody's gonna take up the call for a violent revolution and do it. I mean, they say no present danger of an attempt to overthrow the government by force on the part of an admittedly small minority who shared the defendant's views. So, but as you say, that's in dissent. So they're still losing at this point. There is a fine point of this case, and that is this is the Supreme Court says almost in passing that the First Amendment and the Bill of Rights applies to the states as one of the liberties protected by the Due Process Clause of the 14th Amendment. So up until this point, this is 1925. Up until 1925, no part of the Bill of Rights, the First Amendment or any other part of the Bill of Rights had been applied against a state law. And what this decision is saying is that the Due Process Clause of the 14th Amendment, which protects liberty from being taken away without due process of law, that the Due Process Clause of the 14th Amendment applies portions of the liberty from the Bill of Rights to the states, and the states have to abide by them. And if a state law violates those liberties, it's unconstitutional. So this is the first time that the Bill of Rights is being applied against the states. The person still loses, but that was a very big change. Next case is thanks for good summary. Were you going to add anything else you want to add about that, about Gitlow?
No, not really, but the 14th Amendment, it also has birthright citizenship included in it, right?
It does. Yes. Well, I mean, I guess we'll find out if the Supreme Court ever takes it up squarely, but as it's been interpreted to this point, the 14th Amendment does have a provision for birthright citizenship. There's some really powerful parts of the 14th Amendment. The birthright citizenship, that anybody born in the United States is a citizen. That's one powerful portion. The Trump administration claim is that because that birthright citizenship is qualified with born in the United States under U.S. jurisdiction, And they're saying, well, an illegal immigrant is not under, or the progeny of an illegal immigrant are not under your U.S. jurisdiction, so the 14th Amendment doesn't apply. The Supreme Court in a case 100 years ago said that anybody born in the United States was a citizen. So I think that this current Supreme Court will probably agree with that. The other two really important parts of the 14th Amendment are due process clause and equal protection. So the 14th Amendment was added to the Constitution after the Civil War, 1868, I think it was, that it was ratified. A lot of the southern states had to agree to ratify it to come back into the Union. And so the due process clause carries a lot of weight. And what that part of the 14th Amendment says is that the government can't take, that no state can take away a person's liberty or property without due process of law. And that is that liberty protected by due process of law is what's used beginning with Gitlow to protect most of the liberty of the Bill of Rights from being infringed by the states. So, for example, when the Supreme Court ruled about 10 years ago that states couldn't have laws banning handguns because it violated the Second Amendment. This was a Chicago case. They were doing that under the liberty protected by due process of law. When you get to same-sex marriage, I mean, we're not going to study same-sex marriage in this course, but the Supreme Court relies on says that same-sex marriage, whom you decide to marry, is one of the things that's protected under the liberty protected by due process of law. And this was also before the Supreme Court overruled Roe versus Wade. The Supreme Court relied upon liberty protected by due process of law to say that a woman has the right to control her matters of procreation with her in advice with their doctor. But the Supreme Court said that said several years ago that I guess 3 years ago, maybe 4 years ago at this point, that was an incorrect interpretation of due process of law. There are a number of cases where the Supreme Court has put together liberty protected by due process of law with equal protection. They did that partly in the same-sex marriage case. They did it earlier in a case called Loving versus Virginia, which would be another movie that would be interesting to watch. Loving was the case that was Supreme Court in 1968 ruled that state laws that were prevalent at that time that made interracial marriage illegal were unconstitutional, violating a person's liberty protected by due process of law, and also violating the equal protection of the law. I had the privilege of interviewing Mildred Loving, the person who was involved in that case, when I was a reporter for the Post-Dispatch in Washington, D.C. And I went down to interview her in her very rural Virginia hometown where the whole case originated. And I took along my 5-year-old son with me, and she gave him cookies and milk while I interviewed her. So that term, liberty protected by due process, is a very powerful term. It's also the basis of saying that women have the right to birth control, to contraception. There's a case called Griswold versus Connecticut, where state laws that made it illegal for, at that point, married women to get contraceptive advice or contraceptives to use. Griswold versus Connecticut, which was like 1967, ruled that that violated liberty protected by due process of law. So, very powerful part of the Constitution. And also, the equal protection, that was the first time that the equality principle was in the Constitution, 1868. The Declaration of Independence says all men are created equal. But the Constitution does not have equality in it anywhere. I mean, you could maybe argue we the people is and sort of rests on some sort of equality principle, but the word equal is there are a number of things in the Constitution that aren't in the Constitution. Equality, democracy, direct election of representatives, etc. Okay. I'd like to get to the Whitney case before we break up today. Charlotte Whitney was a sort of a socialite in Oakland, California, and she belonged to a socialist organization, and that included as part of its principles the forcible overthrow of the government. And so this violated California's criminal syndicalism law. You may see, the case, the Gillow case and a number of these other cases where the Espionage Act is not, the Federal Espionage Act is not brought into play. Criminal syndicalism laws are. And so it's sort of like the state version of the Espionage Act. Whitney was convicted of violating California's criminal syndicalism law, and she loses also. But by this point, Brandeis is writing he doesn't really write a dissent. By the way, did anyone have Whitney? I want to present it. I don't want to go ahead and do this if somebody was counting on presenting it. Brandeis writes this concurrence of his is got some language in it that's very famous. I say it's a concurrence because he agreed with the court that she should be convicted based on some sort of sort of technical issue in the case. But then he basically defends as a very forceful defense of free speech. He said the founding fathers believe that the freedom to think as you will and to speak as you think are means indispensable to the discovery and the spread of political truth. So he's sort of, this is like a more kind of communitarian defense of free speech. If you think about Oliver Wendell Holmes and Abrams has got this free market, sort of libertarian defense of free speech and the free market of ideas, truth will come out. Brandeis was more of a communitarian, that free speech is a necessary tool of democracy to spread political truth. The greatest threat, the menace to freedom, is an inert people. Men feared witches and burnt women. It's the function of speech to free men from the bondage of irrational fears. He says that if speech is going to be punished, there has to be a serious evil and imminent danger. And you'll see in the cases that we talk about next week, the KKK rally in our Ohio farm field, the Supreme Court eventually takes up that point of view. And says that not only does it have to advocate revolution, the revolution has to be about to happen. So I think we'll stop there and we'll take up with the Red Scare period. And Dennis case involving the Smith Act, making it illegal to be an officer of the Communist Party. We'll talk about Joe McCarthy. Good Night and Good Luck is a great movie about the Joe McCarthy period where McCarthy is confronted. And then we'll move on to the Brandenburg versus Ohio, which is the KKK case, and Texas versus Johnson, which is the burning of the American flag case. Any questions? Okay. Very good. Well, Tiffany, why don't you hold on just in case you have some. Tiffany is in the graduate version of this course and that has some additional requirements. And I just want to see if she has any additional questions to put to us. But thank you for presenting Gitlow, Braden. That's good.
Oh, no problem.
Okay.
See you next week.
See ya. Bye-bye. Tiffany, you got any questions?
I do not. Thank you.
Okay.
Sorry, I got nervous presenting Shank.
You did just great. Thank you. I gave you 30 points or something. Anyway, you did just fine. That's great.
Thank you.
And we can talk more as time goes on about the paper for later in the semester. So
Okay.
I'll see you next week.
All right. See you next week. Thank you.
Bye-bye.